Good evening, everyone. I'm Antionette Warren, CEO and founder of Warren Publishing Group, which is a Senior Advocacy Alliance, which provides information to seniors through a e-newsletter. It's free new e-newsletter, through community outreach, a speakers bureau, and philanthropy. And we're almost ready to celebrate our 10th year of successful advocacy. Woohoo! And I'm so excited that we continue to bring information to stop the atrocity of elder abuse. This is our second year of bringing great information to everyone for people to get their business in order, so there'll be no problems and people trying to take advantage of you as you are aging in place. I would like very much to thank my administrator for Zoom, Amy Chu, who takes care of things for us for each Zoom presentation. I would like to welcome our co-presenters who have been with us for the last 2 years as well. And I'd like to, I'm not sure if someone is present from the Alameda County Care Alliance. And I guess we'll have to introduce them at a later time, but they have been supporting Warren Publishing Group for the last 2 years. Special thanks to them. And I am really excited and so grateful that Madam President Maxine Hickman is here this evening. The National Coalition of 100 Black Women, the San Francisco chapter, have been our co-presenter as well for the last 2 years. And I'd like to welcome you, Madam President, and I am a member of the San Francisco chapter. So please welcome Madam President Maxine Hickman, and please, if you'd like to say a few words about the National Coalition.
Thank you, Antionette. My name is Maxine Hickman. I'm president of the National Coalition of 100 Black Women San Francisco chapter. As Antionette has said, the mission of the Coalition of 100 Black Women is to advocate on behalf of Black women and girls to promote leadership development and gender equity in the areas of health, education, and economic empowerment. So tonight's workshop is actually a part of our economic empowerment program. We believe in gender equity, inclusion, respect, racial and social justice, integrity, and accountability, economic empowerment, and collaboration. And this workshop is in collaboration with Warren Publishing Group and their Senior Advocacy Alliance. As that and Antionette said, we've been collaborating for the past 2 years. And thank you, Antionette, and congratulations on nearing your 10th anniversary.
Thank you so much, Madam President. And now I'd like to introduce my partner in many of the presentations for the last 2 years, Jorick Gaines, and he is going to share information about what he does. Jorick.
Well, I'm going to keep it really simple. Again, my name is Jorick, spelled J-O-R-I-C-K, as you probably see. I think it's there. Yes. Anyway, I am a financial educator and advisor. We teach people how money works because it's not taught in schools and most people have no idea how money really works. We're starting, we're doing something different in that we're starting at the high school and in some cases middle school, and now teaching young kids. The prayer and the hope is that once they graduate high school or college, they'll know at least the basics, the fundamentals of how money works. And this workshop is all a part of that. It is one of our, what we call our 7 money milestones, which the 7th money milestone is protect your estate. And a part of that is this whole workshop that we're putting on is today. We're going to talk about beneficiary designations. I've seen so many problems with that when people pass away, but we'll talk about that a little later on. So that's what I do. I've been in business for over 30 years, even though I'm only 35. I started young. I got a special permission to get licensed at 5 years old. So thank you for the opportunity.
Thank you.
And congratulations in advance of your 10th. I guess they call that, is that a golden or is that in business? Is that a golden or silver or what is that? Silver, I guess, huh?
I think so. I have to look into that as soon as we end up this presentation. Thank you, George.
You're welcome.
So this month of September, on the 21st, we had a presentation on completing your living will. And this evening, we're going to focus in on the durable financial power of attorney. And at this time, I'd like for the administrator to please share her screen. And she is going to get started with the presentation. And if you have questions, please put them in the chat. And at the end of the presentation, your answers will be given. And this presentation, there's clearly an indication that it won't take an hour. So, Amy, if you could get started, that'd be great.
Okay.
Hey,
So,
Amy, Amy, before you do, I think you may have gone and say it, but I just want to say Freewill is the name is free because this is all free to anybody. I just want to make sure that that's not left out. So, you know, attorneys charge upwards of $22,000, $2,500 and up, depending on your estate. And this is a free service. So take advantage of it. No excuses.
Absolutely. And also, at the end of this particular presentation, you'll be able to visit freewill.com and you will be able to access not just completing your durable financial power of attorney, but you'll also be able to complete your living will if you haven't already done so. Thank you. Amy?
Aye. So when you get to the Freewill website, this is the first thing you'll see. It gives you the option to make your will. But since we're focusing on the durable financial power of attorney, we will scroll down and you'll see it's right here. So click learn about this and you'll get to this page. And on this page, you click the get started button to go to the form. But if you scroll down, it'll tell you about what is a durable financial power of attorney, what powers can be granted to them, how Freewill works, and frequently asked questions. So let's get started on the form.
Hey, Amy, I know they can go there, but why don't you go ahead and read that? What is a durable power of attorney for?
I think she was. Yeah.
A durable financial power of attorney is a document that lets you appoint someone as your agent, someone known as your agent, to manage your finances for you if you ever become unable to do so for yourself. The name is made up of 3 parts. First, the authority you grant to your agent is called the power of attorney. Second, a financial power of attorney is one that grants authority over financial powers. It is different from a healthcare power of attorney, for example, which grants authority to make medical decisions. Finally, a durable power of attorney is one that remains in effect even after its creator becomes physically or mentally incapacitated. So this is the form. We'll do the introduction. This durable financial power of attorney, DFPA, allows you, the principal, to designate someone, your agent, to manage your property and finances if you become unable to do so. Part 1, personal. Tell us a little information about yourself to get started. Part 2 is the agent. In this section, you will select an agent or agents to make financial decisions if you become unable to do so. Part 3, powers. In this section, you will pick the powers your agent will be able to exercise on your behalf. You will also have a chance to specify some limitations on those powers if you like. Part 4, other details. Finally, this section allows you to specify other details about your durable financial power of attorney, such as compensation, monitors, guardians, revocation, and the execution of your documents. Now let's go. So if you haven't made an account yet, first time here, you'll fill in your name and your email address. And since I've already made it, we'll log in. And this is where you'll fill in your personal information, your birth date, your address, and if this is your first durable financial power of attorney. And so the next is, this is where you'll designate who your agent will be, right? So fill in their name, their address, and their phone number. The next question is, would you like to designate another person to serve as your co-agent? So if you select yes, we'll save and continue. You'll fill in the information of who you want to be your co-agent. So like a separate person, like Evan Jones, for example, right? Then you'll fill in the address and then the phone number, and then you'll save and continue. But for the purpose of this demonstration, we'll just say no. And this will be, would you like to designate a successor agent? So this, if your first agent, right, is unavailable, the successor agent will be the next person who will execute who will be your power of attorney. Now, DFPAs are created using Freewill, become effective upon their execution. This means that your agents will have the authority to take action on your behalf as soon as all signatures and other formalities have been completed. Although durable financial power of attorneys created using Freewill grant agents the authority to take action immediately following the execution, this does not necessarily mean that an agent can begin using his or her power right away. Agents must follow the instructions of their principal. If a principal instructs his or her agent not to begin acting on the principal's behalf until a certain date or some other trigger event, then the agent is bound to follow those instructions. So next is, in this section, you'll be asked to select the specific powers you wish to grant your agent. We will consider each power one at a time. Although the powers you can grant your agent using Freewill cover many common situations, state laws often allow principals to grant the agents additional powers that are not available using Freewill. If there's a power you want your agent to have that is not covered on the following pages, you may want to speak with an attorney about creating a more customized DFPA. Please also note that a DFPA cannot be used to authorize an agent to make decisions regarding a principal's healthcare. To designate an agent to make medical decisions on your behalf, you'll need to prepare an advanced healthcare directive. And then this is, would you like your agents to have authority to provide for the maintenance of your family? If you're not sure exactly what this power entails, you would click the question mark button over here, and it'll explain to you what this means. Among other things, this power allows an agent to use the principal's assets to, 1, provide the principal's family with funds for shelter, clothing, food, education, and vacations. 2, pay day-to-day bills and other recurring fees, and 3, provide for medical and dental care for a principal's spouse and children. In this context, the principal's family includes spouses or domestic partners, minor children, and any other individuals whom the principal has customarily supported or indicated an intent to support. If this power is granted, it may be prudent for the principal and agent to discuss the standard of living to which the principal and his and her family is accustomed. Doing so can help avoid conflicting expectations about how the agent should exercise his power. So click yes or no. Would you like your agent to have authority to spend money to take care of your pets? And among other things, agents granted this power will be authorized to use the principal's assets to pay for food, veterinary care, and grooming services for the principal's pets. If this power is granted, it may be prudent for the principal and agent to discuss the level and type of care the principal wishes his or her pets to be provided. Next is, would you like your agent to have authority to manage your accounts at banks and other financial institutions? Among other things, this power allows an agent to make deposits, write checks to pay bills on the principal's behalf, and access safe deposit boxes. Many financial institutions now have their own internal power of attorney forms that they prefer a principal to sign before allowing an agent to act on that principal's behalf. If you grant your agent the power to access your accounts at banks and other financial institutions, you may want to review the DFPA form Freewill creates for you with those institutions to ensure they will honor your document. Even if you grant your agent this power, they will not be able to change the beneficiary designations on your accounts. That authority cannot be granted using DFPAs created with Freewill. If you would like to grant your agent that power, you should speak with an attorney. Would you like your agent to have authority to manage your tangible personal property? Tangible personal property means physical property that can be touched, such as jewelry, furniture, clothes, vehicles, and household items. Real estate, however, is not considered tangible personal property. Among other things, agents granted this power will be authorized to sell, insure, repair, pawn, or move the principal's tangible personal property. Tangible personal property may hold sentimental value for its owner. Consequently, principals that grant their agent this power may want to speak with their agent about plans or wishes regarding sentimental items. Would you like your agent to have authority to manage your real estate on your behalf? This power generally allows an agent to manage all aspects of the principal's real estate, including by renting or selling that property, paying for repairs or renovations, and engaging real estate agents to help carry out transactions. Principals that grant this power to the agent must take an extra step after the DFPA is signed and notarized. They need to put the DFPA on file in the public records with the local land records office where the principal's real estate property is located. Doing so helps establish that the agent truly has authority to act on the principal's behalf with respect to that property. If this step is not completed, the agent will be unable to sell, mortgage, or otherwise transfer the principal's interest in his or her real estate. The instructions provided upon completion of your DFPA will explain this step for you in greater detail. Next, would you like your agent to have authority to manage your legal claims and lawsuits? This power allows an agent to manage legal matters related to the principal and his or her property, including by defending suits brought against the principal and suing third parties in the principal's name. Note, however, that unless an agent is a licensed attorney, he or she cannot actually represent the principal in court. Instead, the agent will need to hire a lawyer to appear on the principal's behalf. Would you like your agent to have authority to manage any businesses that you own? This power allows an agent to control and manage the principal's business activities to the same extent that the principal could, which can include supervising, managing, and participating in businesses the principal owns, compensating and discharging managers and employees, entering the businesses into contracts, and liquidating assets. The authority to manage the principal's business interests covers not only businesses owned entirely by the principal, but also partnerships, limited liability companies, and other entities in which the principal is a partner, member, or manager, provided the principal has authority to delegate his or her power to manage any such entities. Principals that grant this power to the agent may want to discuss with the agent their future plans for the business, such as whether the principal will like the business to continue if he or she becomes incapacitated. Would you like your agent to have authority to manage your securities, commodities, and options? A security is an investment product that can be exchanged for value and involves risk. Common types of securities include stocks, bonds, mutual funds, commodities, and stock options. This power allows an agent to manage the principal securities, among other things. An agent granted this power will be able to buy and sell securities, exercise the principal's voting rights or options, collect dividends, and establish or manage accounts on the principal's behalf with securities and future brokers. Many brokerage houses now have their own internal power of attorney forms that they prefer a principal to sign for allowing an agent to act on that principal's behalf. If you have granted your agents the power to manage your these transactions, you may want to review the DFPA form you create using Freewill with those institutions to ensure they will honor your document. Would you like your agent to have authority to conduct insurance and annuity transactions on your behalf? This power covers all types of insurance and annuity contracts, including life, accident, health, disability, automobile, property, and liability insurance. It allows an agent to take action regarding such contracts, including the authority to continue, modify, or terminate any such policy in existence at the time the DFPA is established, pay insurance premiums, and collect proceeds or benefits that are payable to the principal. Even if you grant your agent this power, they will not be able to change existing beneficiary designations for your insurance and annuity contracts. That authority cannot be granted using DFPAs created with Freewill. If you would like to grant your agents that power, you should speak with an attorney. Next, would you like your agents to have authority to manage your digital assets and communications? The concept of digital agents is relatively modern and still evolving. It includes a variety of assets that exist in digital format. Common examples include emails and email accounts, personal websites such as a blog, online cloud storage accounts, and cryptocurrency. Among other things, agents granted this power may pay bills using your online bank account, post on your social media accounts, and respond to emails on your behalf. In addition to having authority to manage digital assets, agents must also have a way of accessing those assets. Some states have passed laws that let agents with this power to demand they be given access to the principal's digital assets by the businesses that manage those assets. It may, however, be simpler for the principal to tell his or her agent what digital assets exist and the associated username and passwords were appropriate. Principals could, for example, write this information in a separate document for the agent. Principals granting this power to the agent may also want to discuss with the agent their wishes for how the power will be exercised. Would you like your agent to have authority to manage your retirement plan accounts? This power covers all types of retirement plans, including pension plans, profit sharing, individual retirement accounts, and employee saving plans. Among other things, this power authorizes an agent to make contributions to retirement plans on the principal's behalf, make decisions regarding retirement plan payment options, and exercise investment powers available under self-directed retirement plans. The power to manage Social Security and military service benefits, however, is not covered by this grant of authority. We will be discussing that power next. If you grant your agents this power, they will not be able to change beneficiary designations for your retirement plans or to waive or change your rights of survivorship. That authority cannot be granted using DFPA created with Freewill. If you would like to grant your agents that power, you should speak with their attorney. Would you like your agent to have authority to manage your government benefits? Among other things, this power authorizes an agent to file claims or applications for governmental benefits on the principal's behalf, collect and manage any benefits issued to the principal under governmental benefit programs, and communicate with government representatives regarding such benefits. For some government agents, such as Social Security Administration and Office of Military Personnel Management, a DFPA that grants an agent this power may not be sufficient. Such agencies may also require the principal to execute a separate form or require the agent to apply for authority to represent the principal if the principal is incapacitated. Would you like your agents to have authority to manage tax matters on your behalf? Among other things, this power authorizes an agent to sign and file the principal's federal, state, and local tax returns, pay any taxes the principal owes, claim tax refunds, hire an accountant to help handle the principal's tax matters, and receive confidential information from the IRS. This power covers all types of taxes, including federal, state, and local income taxes, gift taxes, estate taxes, and property taxes. Would you like your agent to have authority to manage your interest in any estate or trust? Among other things, this power allows an agent to receive payments made to the principal by a trust in which the principal has interest and represent the principal in disputes regarding wills and trusts. It will also allow an agent to disclaim an interest in property, such as inheritance for the principal, if it is for some reason in the principal's interest to do so. Note that this power generally does not give an agent authority over the principal's own estate plan or estate administration upon death. Instead, it allows the agent to act for the principal with respect to trusts and estates in which the principal has present interest. For example, to accept a bequest left to the principal in someone else's will. Granting this power will not, without more, authorize an agent to transfer your assets into a revocable living trust the principal has established. That power will be addressed separately in a later section. Would you like your agents to have authority to make gifts on your behalf? Why would a principal authorize an agent to make gifts? There are various reasons. For example, gift-making authority allows an agent to use the principal's assets to provide birthday and holiday presents to the principal's relatives, just as the principal normally would. It also allows an agent to make charitable donations on the principal's behalf, which may be important to principals who support a particular cause or mission. Additionally, the power to make gifts can help in managing the principal's Medicaid eligibility and minimizing estate taxes, and be used to provide financial assistance to the principal's relatives in case of an emergency. Are there any risks? Yes, the power to make gifts using the principal's assets gives an agent powerful control over the principal's estate. Even though agents are legally obligated to exercise their powers only in the principal's best interest, many principals are understandably uncomfortable giving their agents so much control. Before granting this power, principals should carefully consider the risks of financial abuse and fraud and whether the agents can be trusted to act in the principal's best interest. Can a principal limit an agent's gift-making authority? If you choose to grant this power, you will next have the opportunity to specify the recipients to whom your agents are authorized to make gifts and the total value of gifts your agents will be authorized to make in a given year. In general, principals granting this power to the agent should discuss the principal's wishes and expectations regarding gifting. Furthermore, documenting any gifting plan to record the principal's intent may also be advisable. Would you like your agent to have authority to transfer your property into revocable living trust you have established? A revocable living trust, also known as a Revocable inter vivos trust is a trust used in estate planning. It is created while the person whose estate is at issue, the grantor, is still alive and allows the grantor to specify who should receive the trust property when the grantor dies. To work properly, however, the grantor must transfer ownership of his or her property to the trust. Agents granted this power will be authorized to transfer the principal's property into revocable living trusts created by the principal. Note, however, that the agent will only be able to transfer property of the sort he or she has been authorized to manage. For example, an agent will only be able to transfer the principal's real estate to a living trust if the principal has been granted power to manage the principal's real estate. Would you like your agents to have authority to exercise fiduciary powers you have the ability to delegate? Some examples of fiduciary powers include serving as the trustees of a trust and as the executor of a will. Not all individuals have fiduciary, I can't say it anymore, fiduciary powers. Not all fiduciary powers can be delegated. An agent will only be able to exercise those fiduciary powers that the principal has authority to delegate. If you have questions about this power, you should consider speaking to an attorney. Would you like your agent to have authority to delegate their authority under the DFPA? The ability to delegate authority to a third party can be valuable when the agent is unavailable for some reason or unable to appear on the principal's behalf. For example, if an agent is going on a long vacation, the agent can delegate his or her authority to act on the principal's behalf to a trusted person until the agent returns and takes over again. It is also useful when the principal has appointed co-agents that must act jointly. If one co-agent is unavailable to act for some reason, he or she can simply delegate authority to the other co-agent, allowing business to continue as usual. That being said, the power to delegate authority is not to be taken lightly. Agents must always exercise their powers, including the power to delegate authority, in the principal's best interest. Nevertheless, by empowering agents to delegate to third parties, the principal sacrifices some degree of control over who is able to act on his or her behalf. Furthermore, when a principal has designated co-agents and allowed them to act separately, there will already be built-in protection against the unavailability of one co-agent, reducing the utility of the delegation power. Why might the principal grant this power? The power to delegate authority to a third party can be valuable when the agent is unavailable for some reason or unable to appear on the principal's behalf. For example, if an agent is going on a long vacation, the agent can delegate his or her authority to act on the principal's behalf to a trusted person until the agent returns and takes over again. It could also be useful when the principal has appointed co-agents that must act jointly. If one co-agent is unavailable to act for some reason, he or she can delegate authority to the other co-agent, allowing business to continue as usual. Are there reasons to not grant this power? When the agent is authorized to delegate to third parties, the principal necessarily sacrifices some degree of control over who is able to act. I think I'm just repeating myself. Next. Will your agent John Doe be permitted to personally profit from transactions he or she conducts on your behalf? By default, agents are not permitted to personally benefit from the transactions they conducted for the principal. This is to avoid conflicts of interest that could tempt agents to take actions that are not in the principal's best interest. For example, if an agent has authority to conduct real estate transactions on the principal's behalf, the agent might be tempted to sell the principal's house to his or herself at a discount. Sometimes, however, it might make sense to let an agent profit from actions taken on the principal's behalf. For example, when the agent is the principal's spouse or close relative, or when the agent is the principal's business partner and the finances are already connected. Here's an example. Alice is Pete's spouse and also his agent. Together, Alice and Pete own a piece of real estate, and Alice determines that it will be in Pete's best interest for the real estate to be sold. She then finds a buyer willing to buy the property at a great price. Because Alice stands to personally benefit from the sale, it would be prohibited unless Pete's DFPA allows Alice to personally profit actions taken on his behalf. This is separate from the earlier question about whether your agent would be authorized to make gifts to himself or herself. Phew, you have finished specifying the powers that you'd like to grant your agents. Now we will go over some final details. Will agents be entitled to compensation for their services? By law, if your agents spend money out of pocket while acting on your behalf, they are entitled to receive reimbursement from your estate. A separate question, however, is whether your agents will also be entitled to compensation for the time and effort they spend working on your behalf. For example, if an agent must drive to another city to settle a claim against the principal's estate, he or she might incur expenses related to gasoline and parking. The agent could then obtain reimbursement of those expenses from the principal's assets. In this context, compensation means the money that an agent receives for his or her work and time spent handling the principal's affairs. Is compensation necessary? It depends, because serving as an agent can require a lot of time, effort, and money. Principals sometimes choose to offer compensation as a way of expressing gratitude. Some agents, in fact, may decline to act as an agent if compensation is not provided. On the other hand, spouses and children routinely serve as agents without any compensation. Before executing the DFPA, principals should discuss the question of compensation with the designated agents to ensure everyone is comfortable. What is reasonable compensation? What constitutes reasonable compensation depends on the circumstances. Where do the principal and agent reside? What is their relationship to one another? What set of tasks is the agent handling? Choosing to provide for reasonable compensation rather than specifying a fixed amount thus allows for some flexibility, but introduces some uncertainty as to what the principal's estate will ultimately have to pay. Here, you can nominate a guardian of your estate in the event your DFPA is set aside or declared invalid. Would you like to nominate a guardian of your estate? What is a guardian of an estate? The guardian of an estate, also known as a conservator, is an individual appointed by the court to manage an individual's property. This commonly occurs when a person becomes incapacitated and did not prepare a DFPA in advance, meaning there's no one legally authorized to manage that person's property. Generally, a court would select the guardian based on who it thinks the incapacitated person would have wanted to manage another individual's property. Isn't this like what an agent does? Yes. Preparing a DFPA allows principals to avoid court-run guardianship proceedings and instead select an agent to manage their property in the event they become incapacitated. However, DFPAs are sometimes set aside and invalidated. If that happens, then the agent chosen by the principal will lose his or her authority, and the appointment of a guardian may be necessary after all. With this question, principals can use their DFPA to nominate someone as the guardian of their estate. Courts will usually honor such nominations. Why would a DFPA be set aside or invalidated? A DFPA can be set aside or invalidated if it is challenged in court. Challenges to DFPAs are uncommon. They are typically brought by a relative who is disgruntled by the principal's choice of agent or who disagrees with the way the agent is managing the principal's estate. If the court is persuaded that the principal was tricked into signing the financial power of attorney, or not of sound mind when he or she executed it, or that the document was legally defective in some way, it might set aside the document and instead appoint someone else as a conservator or guardian. Would you like to nominate a guardian of your person? The guardian of a person is someone appointed by the court to make decisions regarding the physical health and well-being of another. This commonly occurs when a person becomes incapacitated and did not prepare an advanced healthcare directive in advance, meaning there is no one legally authorized to make such decisions for them. Generally, a court tries to select the guardian based on who it thinks the incapacitated person would have wanted. If the person's DFPA nominates someone to serve as a guardian of his or her person, the courts will typically respect that nomination. So if you click yes for this, the guardian of your person or guardian of your, whichever that one is, you'll be able to name the person, include the address and their phone number. This DFPA will include a preparation statement that sets forth the name and address of the person who prepared the document. The name and address you provided for the principal are filled below. If this is not the name and address of the person preparing this DFPA, please enter the correct information below. So once again, your name and address. And this is, Ohio law does not require DFPAs to be signed in front of a witness to be valid, but you may want to do so anyway. So this is basically how many witnesses will you want to use when you're signing your DFPAs. And this is your review. If you want to make any changes, this is where you would do it. And that's basically it. Then you could print and sign it, create your free will, or help a loved one. That's it.
Thank you, Amy.
Phew.
You see how important assigning who is going to handle your durable financial power of attorney, because actually if you don't have one, and you could end up in probate court where the court would assign a conservator, and that conservator would then take care of everything that Amy just went over. Okay, and so that person would have the authority to make decisions for you. Whereas if you do this now, you are in charge of your property, your finances. So very interesting, a lot to cover. And so at your leisure, sooner than later, you can go to freewill.com and read over the durable financial power of attorney. So Jorick, I am going to turn this over to you for your remarks, and I will see if we have any questions. Thank you.
Oh, okay. Well, the first thing that stands out to me, and hopefully those of you, if you have any assets, you know, there are so many areas that can go in the wrong direction. And man, I couldn't even count them all. That's why it is imperative, if you have any assets, like was mentioned, real estate, retirement plans, annuities. And now, the one thing I will say about annuities, life insurance, retirement plans, those kinds of assets, even bank accounts at some banks, generally there's a beneficiary named, but this durable power of attorney is before the person dies. So they get dementia, they get Alzheimer's, they have some debilitating, and those are the most popular and most common ones, because one of the most common things that happens to those older folks, or those folks with those somewhat brain diseases, is somebody's taking advantage of them that has access to their assets, and they may not even have, most people, I can tell you from experience, most people don't have a durable financial power of attorney. And it just creates all kinds of problems, and families feuding, and everybody's got an attorney, and nobody's trusting anybody, and it's a nightmare. So, of course, I highly recommend that you put that in place. It you know, if you have a simple estate, it's still critical, because you've read all of the different things. I mean, you got bank accounts, you've got real estate if you own rental property, or whatever the case may be. So as you can see, I think that presentation, and thank you, Amy, if it doesn't make your head spin, I don't think anything will. But I think if nothing else, it tells you need to talk with someone. Look at that document, see if you want to take it on yourself. And if you have a complex estate, I highly, highly, highly recommend you seek legal advice. Yes, legal advice is not cheap, but not having it is a lot more expensive. So we're going to open it up for questions. And I want to give my disclaimer. I am not an attorney. I am a registered investment advisor nationally, all 50 states, life insurance, and I have insurance licenses in life and health and disability, as well as property and casualty. And I'm a California real estate licensed broker. So I've seen a lot of this stuff over my 35, 40 years of experience. So, and it's never pretty. So get with someone if you have assets, make sure that what you have goes to who you want to get it, put it in writing, get it acknowledged, notarized, recorded, whatever is required to make it valid, and talk to the people. The one thing I got out of this, if you didn't get it, is whoever you decide to appoint, or if it's more than one, you need to sit down and have a serious conversation with them about what your desires are, what you want to see happen, what your wishes are, so that they can be carried out. And in some cases, you might even want to use a third party. Some banks offer representatives that can do that. There are private companies that'll do it. So if you don't have someone that you trust immensely, you might want to hire somebody. Again, it costs, but not having it cost even more, and not to mention the burden it puts on your family and everyone else that's concerned. So, but there are trust companies out there. Some banks have trust departments, and have people that can act as your fiduciary or your financial power of attorney. And a fiduciary responsibility is they have to act in your best interest when required to do so.
Mhm.
So
Thank you, Jorick. Are there any questions? Okay,
did
so
we
I'd
check
like
the
to,
chat? Let's see.
so I'd like
Thank you.
to invite everyone back for our October elder abuse awareness. On October the 12th, we'll go back to freewill.com and we will cover beneficiary, designation, and healthcare directives. And then on October the 26th, these are Tuesdays, October 26th, complete your revocable living trust. So please share this information with with seniors, family members, caregivers, friends. Everyone is welcome to participate so you can share the information so we can take care of each other, our family and friends.
Antionette, I would just wanted to add, for those of you that have family, I know sometimes it's hard to get family to get on these things, but they need to see these things so they understand not only what they need to do to protect their assets, but also what could go wrong. And if you didn't figure out at least a dozen things that could go wrong if you don't do it right, you weren't listening. So get your family members here, get them to understand the importance of it, especially if they're a little older, because sometimes older people say, oh, I'll let them deal with it when I'm gone. I'm not going to worry about it. I won't be here. That's not a good strategy.
And that brings up the point that not just seniors need to know about this, but young folk need to know about this so they can look to make sure that their older family members and friends are taking care of business, and you can encourage them and get your business together before you end up forgetting about it, and then you end up being a victim of elder abuse. Thank you. Would you like to say anything else, Jorick?
I was just going to say, we often, I think we're all guilty of it. We think more of older people, but they're young people with assets, and who knows if they might not get Parkinson's or some of these debilitating Lou Gehrig's
Or COVID?
yeah, well, yeah, that's not good. But I'm just speaking, they're still here. They don't leave. But yeah, if you're COVID and you're on a respirator and you're in the hospital for 30 days, I just was talking to somebody yesterday. Somebody's been in the hospital for 25 days. You pray they come out of it, but we know more so than not, they don't. And then people are scrambling, trying to get that done before they pass. And unfortunately, a lot of those things will be considered invalid because of the circumstance. So it's always better to have a plan in advance of that stuff happening. So think about that as well.
And it's more times than not that people have their business in order, unfortunately.
Yeah, it is unfortunate.
So thank you, everyone. And I hope that you have a blessed, wonderful evening. And I'll look forward to seeing you next month. Be safe, be well. God bless.
Thanks, Antionette.
Thank you, Jorick.